The Trans Mountain Pipeline expansion has cleared another huge hurdle. Today, the Federal Court of Appeal dismissed an appeal by some Indigenous groups. They were arguing that the feds had not meaningfully consulted First Nations affected by the project's construction before approving the pipeline for a second time. Political reaction to the court's decision so far has been pretty mixed.
I think this removes the last remaining legal obstacle to the completion of the Trans Mountain expansion. This has been through years of exhausted reviews. The public supports it. Overwhelmingly, Aboriginal groups support it. The cabinet has reviewed it twice and approved it. And now the courts have spoken yet again.
Judges, which incidentally have been named by the federal government, have interpreted Canadian laws. And that clearly Canadian laws say that when the federal government wants something, that's the thing that's going to happen, whatever provinces might say. I will repeat, I said that those judges are nominated by the federal government.
What's the purpose of saying that?
I think people can understand that.
We're going to speak with the chief of one of the First Nations that brought the appeal in a few minutes. First, though, what's next for the government on TMX? Paul Lefebvre is the Parliamentary Secretary to the Minister of Natural Resources. Hi, Mr. Lefebvre.
Hello.
Thanks very much for coming in. Minister O'Regan said today in response to this decision and to the Indigenous groups who are affected by it that even though they lost the case, they are seen, they are heard, and the federal government will continue to talk to them even as construction on the TMX expansion continues. What exactly does that mean given this decision?
Well, that means that we keep engaging with them. That means we have continue the conversation because, as we know, it's a big project and there are concerns, and we are striving to obviously to address those concerns as best as possible. And so we have a series of during obviously the last consultations, we have a lot of examples that have proven that we were able to move forward with the project because of the engagements that we've had with the communities. And then obviously, because we take our duty to consult very seriously, and that's what the court has actually decided, obviously, because we took it very seriously and we sought where to consult, and then we had a duty to accommodate where we could. And we did that, and that's why the decision was rendered.
Yeah, that's what prompted my question, though, because the decision is very explicit that, in fact, the government has accommodated where needed. So are you saying that the federal government is prepared to accommodate even further?
Well, actually, the court actually said that because we're on the path to having those discussions, and we started those discussions, and those discussions are ongoing. It's a path that because these are the phase 4 consultations, and even though when cabinet made a decision to move forward with the project, it didn't mean that we stopped engaging. Right, and we're not going to stop engaging because, again, there are concerns that the communities have.
But engaging is, with respect, engaging is different than accommodating, right?
Yep.
So yes, you're going to continue talking, and that's what the minister said today.
Yep.
But does that mean that should one of these communities come forward and say, hey, I'd still like the route moved, you will consider that?
Well, those are, again, everything is still up for discussions. But at the same time, what the court has said is that or the path forward that they had originally provided to us in August of 2018, that we had fulfilled our mandate to obviously to follow that path, and we respected their decision. Now, that being said, like I said before, we take our duty to accommodate very seriously and our duty to consult. And so that's why it's important that we continue engaging with the communities and where we can find, excuse me, a path that we can work together towards. We could, but and at the same time, what the court has told us is that it doesn't mean that they have a duty, they have a right to stop the project. But we don't feel that that's, given that they don't have a veto right, that we can just push through the project that we see it.
Are you worried, though, about sort of the collision of messages there? Because the court is explicit in basically laying out that your duty to consult does not equate to a veto.
That's right.
But at the same time, your government has made pursuing an agenda where reconciliation is concerned a top priority. In fact, you say that you've pledged to introduce UNDRIP legislation within the next year.
Yeah.
How do you understand how there will be mixed messaging for a number of Indigenous groups and people in this country who are affected by that?
And that's why the decision is so important. And it makes it clear that we have a duty to consult, and we have a duty to where we can find grounds to accommodate on when certain obviously factors arrive, that we do so. But at the same time, actually, the court is quite clear that a duty to consult does not mean obviously having a veto right.
But does that take away some agency from Indigenous people in this country while they are listening to you and your government say that you want to pursue reconciliation?
No, I think actually when we looked at the legislation that we brought forward with the Impact Assessment Act back in June of last year, we want to make sure that Indigenous engagement is at the forefront and not at the tail end of major projects. I think we need to make sure, and I think actually this decision, the way that certainly the phase 2 consultations were done on TMX is the right blueprint to follow on major projects. That means that when we're stakeholders and that they want to move forward on a major project, they need to make sure that they're engaging with the communities at the forefront. And that's what I think we had failed in the first place. And obviously that's where the court provided us an opportunity to fix that, and we did.
Some of the groups affected are pledging to follow through on this beyond any legal recourse they have. They obviously have one appeal they have to decide on in the next 60 days. But we've seen examples of, for example, with the Wet'suwet'en hereditary chiefs and the protest or the blockades of the Coastal Link pipeline. How far is your government prepared to go to ensure that the construction of this pipeline proceeds if, in fact, those blockades arise?
Well, first of all, the construction is already ongoing. There's already
proceeds, even further, though. It still has to go through that
exactly.
area.
It has to go through areas, but that's why we continue to engage, right? And basically, people have a right to protest, but at the same time, we need to respect the court's decision. We can't just.
What does that mean? I understand what you're saying, but that's kind of a political answer, right? Are you willing to send in the RCMP, and do you, again, if you are, do you recognize what that does to the image of or the message of reconciliation?
I think what we, and that's why we've taken this duty that we have to engage with the communities very seriously. We prefer dialogue, obviously, towards any other means of enforcing a major project. That's what we've done in the first place, because we know that in the past, these obviously when you have these disputes, trying to enforce anything, try to bulldoze your way through does not work, and that's why we are engaging. We've obviously that's why the court decision has come down in our favor.
But if the engagement fails, right, and there was a lot of engagement done, I'm asking because on the Coastal Link pipeline as well, right? The company thought it had a ton of the communities affected on side.
Right.
It looks like that isn't the case in at least certain respects. And what we're hearing from the groups affected by this decision is they're prepared to do the same thing. So it's a hypothetical, but it's not that hard to imagine.
Well,
and I'm just asking you in real terms, how far is your government prepared to go to make sure the pipeline is completed?
Listen, everybody has a right to protest in Canada, as long as they do so peacefully. That is a right that everybody has. However, that being said, we have a court decision that has just been rendered, and obviously provided that because obviously that we had followed the court's decision and the path that they had provided us, and we had properly followed that path, they have given us cause to move forward with the project. And I think it's all, Canadians should be assured that we should be respecting court decisions, even though sometimes they don't, we don't agree with it. It's important that we respect those decisions because that is the rule of law, and we should, people should be abiding by that.
Okay, I'm going to leave it there. Thank you, Mr. Lefebvre. Pleasure having you here.
Thank you.
Indigenous communities at the center of the appeal are expressing disappointment today. Lee Spahan is the chief of the Coldwater Indian Band that helped launch this appeal. He joins us now from Vancouver. Hi, Chief Spahan. Thanks for making time for us.
Hello, Vashi. Thanks for having me.
Chief, I want to read to you part of the decision and get your reaction. The court did say that too often decisions affecting Indigenous peoples have been made without regard for their interests, but went on to say where there is genuine disagreement about whether a project is in the public interest, the law does not require that the interest of Indigenous peoples prevail. What's your reaction to that?
My reaction to that is it sounds disrespectful. The government of Canada wants to move forward with reconciliation with First Nations peoples and doing it in a meaningful way, but yet, I've heard twice today how they say they want to look at consultation seriously and move forward in a good way, but yet, when we, Coldwater, has concerns and issues with what's happening with the Trans Mountain Expansion Pipeline, we feel like that meaningful doesn't sound so meaningful anymore.
Let me ask you, for our viewers who might not be as familiar with the case, and correct me if I'm wrong, but One of the primary concerns from the Coldwater Indian Band was that the pipeline's route could directly affect the water supply. The government proposed basically a testing system that they would put in place. Why is that not enough to allay your concerns?
Well, the water aquifer study was put in place because of the last court decision. But yet, you know, with moving forward and they said, oh, well, let's work in collaboration with Coldwater. But yet, when they put that report forward, they're the ones who imposed the deadline to it. And the water aquifer study hasn't even started yet. And they expect to have a complete report by end of April. That's only 2 months. How can they consider that? You know, it's not working in collaboration with Coldwater, and it, you know, like I said, it's not in a meaningful way.
You heard me, I think, ask the parliamentary secretary there about how far the government is prepared to go to make sure the pipeline is built. How far are you prepared to go to ensure the opposite?
In discussions with my counsel and our legal team this morning, you know, we agreed that we will do whatever it takes to protect our sole source drinking water for our community and for the future generations of the children that aren't even born yet in Coldwater. And, you know, that's a heavy statement because, you know, we go to court with Canada and we tell them about our concerns and our issues that we have with them, but yet, you know, they still decide like it's in the best interest of Canada to move forward with it. And yet you hear Justin Trudeau saying, oh, well, we're going to get rid of all the water boil advisories for First Nations. And how can he say something like that when he's going to put a pipeline right through the middle of our sole source drinking water, our aquifer? What kind of reconciliation is that?
What does whatever it takes mean?
Well, the mandate that Chief and Council got from the community members was protect our water. And, you know, that's what we have to do is, you know, we ask Canada, like, what are you going to do if our water gets contaminated? Are you guys going to move our reserve out of the location we're at now, or what's happening? You know, I attended a meeting with called Our Gathering a couple of weeks ago, and you know, the regional director general came to the meeting and stated, oh, there's $1 billion for First Nations in British Columbia. But yet when I ask a question about infrastructure, such as the water infrastructure, because, you know, in all First Nations in British Columbia, we have housing problems, but you can't build a house without having water. But yet, you know, when we bring questions up about the water infrastructure, you know, how much money is actually put towards that? And I want to give you an example. In Coldwater, we have 3 reservoirs. The main one is the one that feeds 90% of our community. We have 2 other reservoirs that are 25 years outdated. And, you know, we ask Government of Canada, is there going to be funding put aside for water infrastructure, for our water lines, our water reservoirs? And we need to build these water lines for our members.
Okay.
To sustain a quality of life.
Understood. I have to leave it there, Chief. Thanks very much for your time this evening. That's Lee Spahan, Chief of the Coldwater Indian Band.
Thanks for having me.
Today's court decision on TMX is welcome, but it's not enough. It was supposed to be in service 2 months ago, and the Liberals are losing $20,000 a day on it. What's still missing is a concrete plan from them. What will these Liberals actually do against these threats, and when will they guarantee an in-service date for the Trans Mountain expansion?
Today, work on the Greater Edmonton Pipeline construction is underway. Work at the Edmonton Terminal and the Kamloops Terminal is underway. Work at stockpile sites at Northgate, Merritt, Enoch, Cando, and Edson underway. Work at pump stations at Edson, Hinton, Black Pines underway. TMX is being built, Mr. Speaker.
Not good enough. That's the Conservative opposition's reaction to the news some TMX appeals have been dismissed. The Federal Court of Appeal rejected 4 challenges today made by affected First Nations. So is it clear sailing or digging for the expansion of the Trans Mountain Pipeline? And what does the ruling mean for the First Nations opposed to the project? Let's bring in the Power Panel to discuss. In Vancouver, former Conservative Cabinet Minister Stockwell Day. Over in Calgary, Maclean's Jason Markusoff joins us. Nigan Sinclair, columnist with the Winnipeg Free Press, is in Winnipeg. Over in Toronto, Supriya Dwivedi, host of the morning show on Global News Radio 640 Toronto. And here next to me in studio, she's back, former NDP MP Françoise Boivin. Hi, everybody.
Bonjour. Hello.
Nice to see you. Nigan, I want to start with you. What do you think the impact of today's decision is?
A federal decision by federal judges in the interest of the federal interest. I mean, no surprise here. There's even the 9,000 pages that the 4 First Nations provided still isn't enough. And the fact that this consultation process is so deeply flawed because it involves First Nations way at the back end. First Nations are never involved on the consultation of projects till they're well basically decided upon, and no surprise, yet another approval in the federal interest.
Okay, let me challenge you for 1 second and see what you probably have a better perspective on this than me. But this is the argument put forth by Yves-François Blanchet, the leader of the Bloc, today as well. This idea that the judges are sort of in the pocket of the federal government, and I'm not taking your words specifically, I'm paraphrasing, because they're federal judges, and ultimately they're going to decide, in favor of the federal government. Isn't this the same court that made the decision in the first place, I think it was in 2018, that what the feds had done was not enough, and basically said this decision doesn't stand, it has to go back to cabinet?
No, this came from the decision on overturning the appeal had to do with more a retired federal court judge that looked at the decision, decided it was flawed, as well as the environmental flaws that involved with the decision.
But I think that came from the Court of Appeal. Supriya's a lawyer, right?
It is. It was from the Federal Court of Appeal. It's the same court.
Deciding the decision was inappropriate in the first place, or taking it back to another round of discussions, was also in the interests of looking at, it was a pre-federal government, federal election. And now what we're looking at is, First Nations just have to keep looking at being told, oh, this is just another pipeline, just keep believing in the letter of the law. This is an exact situation in which First Nations are continuing to being asked to wait, and then the decisions always turn out in the interest of the federal government.
Supriya, what do you think about that?
Look, I think there are definite legitimate criticisms to be made, particularly as it pertains to the court's opinion on Section 35 jurisprudence and how it applies here.
Can you explain that in layman's terms?
Sure, yeah. Section 35 is the duty to consult, and the court made a number of references to case law, basically saying the case law would point to the federal court in this, in the direction of this decision. And so I think there are a number of legal experts that have particular expertise in Indigenous Crown relations who are making that point on social media, particularly on Twitter today. And but to throw the entire concept of judicial independence under the bus, I think is. We get into very dicey territory, particularly when the Bloc leader did so today. Because then, what is the point of anything? This is a major pillar of our democracy. I think, as far as what the government does next, I think for them it's clearly from crass, just political terms, it's clearly a win for them. But I think they have to be incredibly careful here as to how they continue to engage on the issue. And I know the parliamentary secretary you had on earlier was making that point, but you don't really want to come away looking at this as though it's a pure win, because it's not. This does present serious problems and serious ongoing hurdles for them if they actually are committed to the issue of reconciliation.
Yeah, Jason, I wanted to bring you in now because it is, I think, to both Nigan and Supriya's point, that was the part that kind of interests me with the parliamentary secretary, because on one hand he's saying, oh, we're going to continue to talk, to engage and to address and even accommodate the concerns that arise. But on the other hand, this decision lays out a clear path. And I'm just wondering if, in fact, like the chief of Coldwater Indian Band told me, they are willing to do whatever it takes. How far, politically, how far is the government willing to go against the backdrop of saying reconciliation is also a priority for it?
Well, it was interesting to read the ruling. The ruling was, this is, to Nigan's point, this was in Canadian federal law, not Indigenous law. I know that the First Nations who had opposed this project and spoke this afternoon were saying that this is still not valid in Indigenous law. This was being fought in the federal, the Crown realm. So that's as far as that goes. And the ruling was interesting. It addressed the idea of reconciliation. That reconciliation does not mean that that at the end of the day, if it comes down to a dispute between the Crown and First Nations, that the First Nations get their way. These are about accommodations. This was about consulting, having a discussion about this project, and ultimately it was the prerogative of the federal government to decide how to accommodate and whether to accommodate in certain cases. During this process, let's remember that there were 6 First Nations communities that were in this appeal in the fall when it first came out, and by December they were down to 4. 2 First Nations, Upper Nicola and SSN, had reached benefits agreements. So of course they will be trying to negotiate, get Coldwater on our side, get Tsleil-Waututh, get Musqueam, get the other one whose name escapes me right now on side. They won't all be. And that's something that is valid in Canadian law, and that the federal government and the First Nations who oppose this will have to live with. I would add, though, that the court also noted that of the 129 First Nations communities and groups that were consulted or invited to consult on this, 120 either support this or oppose this. So this is actually
do not oppose it.
Sorry, do not oppose this.
Yeah.
This is a support or do not oppose this. So this is actually quite a mixed day for First Nations, the 4 that were fighting this battle and the 120 that don't have a fight in this.
Stockwell, how delicate a dance is this for the government going forward?
Well, the last point just made is an important one, and I think to Mr. Sinclair and others, we live in a day where it's a real reach to say anybody speaks for an entire group of people. That just doesn't happen anymore. All groups have diverse opinions within their own group. And the point just made, of the 129 groups that will be affected directly, 120 either support or are not opposed to it. 43 of those groups have significant arrangements, business arrangements.
They signed benefit agreements.
But these agreements, people, and I think people should be a bit ashamed of themselves, saying, oh, well, they just got bought off. No, I know a lot of the people on those First Nations groups, and they significantly believe that being able to move highly refined Canadian product to countries that are frankly polluting the world with their coal emissions and replacing that with much better refined Canadian products is actually beneficial to the environment also. These groups also, these are Aboriginal groups who approve of the environmental considerations that are put in place, and the judges have now, and I tell you, that's a rare time I've heard that a suggestion that courts are somehow sympathetic to pipelines. Well, out west, that is certainly not the view. But what
the suggestion is that courts are sympathetic to the federal government or to certain political interests, which is a claim the Conservatives made in the last government around the Supreme Court as well. So
yeah, I'm pretty jaded when it comes to the courts, but on these issues, no, I don't think they are. And I think they did a service to show that this does not mean you have to have agreement when you're doing consultation. It means you've consulted, and you're quite right to raise that in 2018 the court said, hey, this consultation was not significant enough. A lot of people thought it was, but they said no, it wasn't. Now, it was so significant that the courts have said, this is a good consultation process. It's precedent setting. It's laid out some very clear rules, but the court also said, when you consult, you don't have to agree. It also said that no group, and that would include First Nations group, no group necessarily has a veto on development just because they say they don't like it. So there are some clear guidelines that have been laid out.
I want to get you again, Nigan. I just want to bring in
we speak for all people.
I want to get you again, Nigan, for sure. I just do want to bring in Françoise as well. And that obviously that veto line as laid out in the decision, I think will likely be pretty significant moving forward.
It is very significant moving forward. And might I remind everybody that these 4 groups have 60 days to go in front of the Supreme Court of Canada. So it might not be the end of it. They might want to hear the view of the Supreme Court on consultation, on veto. So that could be interesting. I won't add to what all the other guys said right now, but I was kind of tickled the wrong way when I heard Mr. Sinclair, sorry, and Yves-François Blanchet, because as a lawyer, I know when I lose, it's obviously because the judge didn't get nothing or didn't understand, and it's always on the side of the unions or whatever. It's so easy to go to that simple thing. I think the same court, not necessarily the same judges, but the same court reviewed the action from the federal government the last time, and they said this was not a real serious consultation. Go back and do your homework. They went back, they did some homework, they go back to court, and they say, now you've done it, and they go through everything. You might disagree, you might agree. Go to the Supreme Court if you're not agreeing that it's enough legal-wise or something. But to put the judge's decision as if they're in the back pocket of the government, I find it's a bit easy porte de sortie, easy exit, and it's really demeaning, and it's a dangerous path to take.
Nigan, why don't I give you the opportunity to respond to that and the final word in this segment?
Absolutely, and notice that I didn't ever say names, and what I did say is that the issue is of Canadian law, and Canadian law always supersedes the interest of Indigenous peoples trying to advocate for their own treaty rights. And by the way, did I mention, there is no treaties that attach to most of this territory that TMX will cross. And so in those situations, Canadian law always supersede, always step upon. And when First Nations try to ask for consultation, which by the way, isn't veto at all, and veto is not the question here, it is the issue of consultation as a principle. When Indigenous peoples are offered a benefit agreement way when the decision is already decided upon, that's not consultation whatsoever. And so what First Nations are asking for is an adequate consultation involving partnership, and perhaps the idea that most of this land in BC is not being held under treaty. There are no agreements in which there are in place that people can have a partnership. So what we're left with is a consultation process which is inherently flawed, and we're involved in the back end. And I don't think anyone has ever said that I or anyone else speaks on behalf of all First Nations people. I think what First Nations people are asking for is a decent partnership, and a decent partnership of fairness and equity.
The Trans Mountain Pipeline expansion can go ahead. That's what the Federal Court of Appeal decided today when it dismissed an appeal by a number of First Nations which claimed the government had not done enough consultation around the $7 billion project. Amarjeet Sohi served as Minister of Natural Resources from 2018 until 2019 and led the government's second round of consultations on this very subject. He joins us now from Edmonton. Hi, Mr. Sohi. Nice to see you. Thanks for making some time for us.
Well, thank you so much for having me.
Let me ask you how you view the conclusion that the court reached. Is this the removal of the final big impediment to the pipeline going ahead? Do you think it's that conclusive?
Well, this is a very significant ruling from the Federal Court of Appeal. When we put this process together to respond to the earlier Federal Court of Appeal of August 30th, 2018, and we knew that we need to do things differently, that we need to engage in a meaningful two-way conversation with Indigenous communities to listen to their concerns and then offer accommodations to those concerns. And so today's decision has validated that if you do things the right way, you can get to the conclusion and have these kind of large energy infrastructure projects move forward in our country.
I guess I'm asking, though, how you see it proceeding or how conclusive do you think it is? Because, for example, we spoke with the chief, Lise Bahan, and I think you've actually met with him as well throughout this process, yes. Correct me if I'm wrong, but of the Coldwater Indian Band, who said that they're prepared, they're obviously going to appeal it, but they're also prepared to do whatever it takes. And we've seen blockades where the Coastal Link pipeline is concerned. And I'm just wondering, from your perspective, now being outside of government, having lived it for so long, if you think that will continue to be a real challenge for the federal government.
I think this court ruling removes one of the biggest barriers as far as the legal challenges were concerned on this project. Absolutely, Indigenous communities who are opposed to it have the right to appeal to the Supreme Court. But I think the unanimous decision from the Federal Court of Appeal and the identification of how the federal government has responded to the issues and how accommodations have been offered is a significant thing. As far as the other challenges are concerned, obviously this is a very controversial project, and the leadership is required on many fronts to satisfy people's concerns on the climate change, on protection of the marine safety, and other issues which this federal government has dealt in the last mandate and committed to doing so as they move forward on this project. But today's decision is a very important step forward as far as legal challenges were concerned.
You've also been writing about, and we've been talking about another big decision where the resource sector is concerned that this government will be faced with in the coming weeks. Cabinet particularly will have to decide on the Tech Frontier mine, a huge mine in northeastern Alberta. They're expected to give that decision, or they have to give that decision by the end of February. And I wanted to get your take again about now having been outside of government and before being around the cabinet table when these kinds of decisions had to be made, how big of a struggle do you think it will be, or how hard a decision it might be for this cabinet, given the competing interests, or the somewhat competing interests, this idea of economic development and the economic concerns posited sometimes against, by a lot of people, the environmental concerns and the climate targets that this government has set out? How much of a struggle, how hard of a decision do you think this is going to be for cabinet?
Well, one thing that I have learned through the Trans Mountain Pipeline Expansion Project, Vashi, is that there are real impacts of resource development on communities, whether it's the protection of water or the cultural sites or the way of life for many Indigenous communities. So you need to find solutions to those issues. So for resource projects to move forward in this country, I believe that dealing with Indigenous concerns, at the same time making sure that governments are taking a strong action on climate change to meet Canadians' expectations, that Canadians want action and the commitments that government has made to be net zero by 2050. All Canadians, all provincial governments have to play a role. So in the context of Tech Resources Frontier Project, and I think the best way to move forward, as I proposed in my op-ed, is that give approval to this project because it has gone through a rigorous independent regulatory review process, but at the same time acknowledge the impact on the climate change and take action, and both governments working together to take a very strong steps towards dealing with the emissions from not only from this project, but overall emissions from the industry and overall emissions from the use of fossil fuels.
Here's the question I have for you. Do you think a pledge, though, that the Alberta government let's say makes, or like Tech has made this week, or that the federal government makes, do you think the pledge to, for example, get to net zero by 2050 will be enough to satisfy people who are deeply concerned about this country's ability to meet its climate targets?
You know, there's a segment of the population in our country that will never be satisfied by any action that governments take because they believe naively that shutting down the oil sector is the only way to meet environmental commitments and our climate change obligations. I don't believe that is the case.
You know that there's a lot of people who question whether the Prime Minister believes that, though.
Well, I can't speak on behalf of the Prime Minister. What I can say is that industry has taken leadership. Major oil companies are moving toward reducing emissions significantly and somewhat putting targets toward being net zero by 2050. Governments have to follow that, and they need to put policies in place, incentives in place, and the regulations in place that those commitments and those aspirations are met, whether they are related to ongoing resource development or the future growth of the resource development. Economy and environment can go hand in hand as long as we take it very seriously what our obligations are to the Indigenous consultations and Indigenous concerns from Indigenous communities, at the same time take a serious action on climate change.
And we shall see how that works out at the end of this month. We'll speak to you again then, I'm sure, Mr. Sohi. Thanks for your time this evening.
Well, thank you so much for having me.
Here's a bit of a primer on the pipeline at the center of this decision. The TMX pipeline expansion would twin the existing Trans Mountain pipeline, which runs more than 1,000 kilometers between Edmonton, Alberta, and Burnaby, BC. That would triple the amount of bitumen flowing through the pipeline to nearly 900,000 barrels a day. The project is also set to expand the terminal in BC and, as a result, could increase tanker traffic there by nearly 7-fold a month. According to the feds, the pipeline and terminal together would produce 400,000 tons of greenhouse gas emissions a year, create the equivalent of 15,000 jobs during construction, and generate about $47 billion of revenue for different levels of government over the first 20 years of operation. TMX was first approved by the Trudeau government all the way back in 2016, but strong environmental and political opposition led Kinder Morgan, the project's owner back then, to bail. In swooped Ottawa, purchasing the pipeline for $4.5 billion. A court decision that same year brought any construction that had started to a stop. Citing inadequate Indigenous consultation and environmental assessment, Cabinet was forced to address the issues and then decide all over again. Last year, the feds approved the pipeline they already owned and construction restarted, with an estimated increased cost of $7.4 billion. Hi, I'm Vashi Capellos, host of Power in Politics. See more of our show by subscribing to the CBC News channel or click the link for another video.